Welcome back, everyone. Next, we will have a presentation on best practices for conservators with Davidson County Probate Master Elizabeth Johnson and Attorney Anthony Burns. And at this time, I'll turn it over to the two of them.
All right, good morning or good afternoon. I'm sorry, I'm Elizabeth Johnson. I'm the probate master for Davidson County, working directly with Judge Kennedy in the 7th Circuit Court, and I am trying to get my video up and running. If you will just give me 1 second. All right, there we are. Today, we're going to talk about conservatorship and finances. Mine and Mr. Burns' idea is to kind of give you an overview of some common mistakes and misconceptions of conservatorships, including giving you some practical tips and guidance for attorneys' fees, for attorneys and conservators, on how to manage financial aspects of conservatorships and how to address some common errors and to avoid them before you have to come before me. What most people don't know is that Judge Kennedy, through the statute 17-123B, has authorized me to act as the probate master for the Davidson County Probate Court. Essentially what that does is that gives me the trial judge authority or powers of the trial judge in any proceedings that he has authorized for me to review. Essentially, we like to say, and even the statute says, that I act as at the pleasure of the judge. Currently, in my role as the probate master, I review all property management plans, inventories, accountings, bonds, show cause hearings, review hearings, and exception hearings that occur in the Davidson County Court. As part of my job, if it is anything in regards to accountings in which I determine a removal is necessary of a conservator or a guardian, where I enter a judgment or recommend a judgment be entered against a guardian or a conservator, or I hear a fee dispute in regards to fees for an attorney's fees dispute or a conservator fee or executor fee dispute. Essentially, I have to do what we call a report and recommendation to Judge Kennedy, in which any party, if they have any opposition to what I have filed, has a right to be reheard in front of Judge Kennedy de novo. And so if no request to my report after a hearing is conducted is heard, the report and recommendation becomes an order of the court upon Judge Kennedy entering a confirmation order. Otherwise, you have a right to ask Judge Kennedy to hear anything that I've heard that you disagree with. In regards to when I review property management plan, inventories, accountings, and bonds, pretty much once I put down an order, if I sign the document, I'm acting in judicial authority and approving that for that particular item, such as a property management plan. If I sign that and find that it is reasonable and appropriate, then the conservator is allowed to act under that property management plan until an additional or an amended property management plan is filed. What we would like to do is I want to just remind everybody, since I am an officer of the court and the one that does review over all of these documentations, one of the things that I issue is show cause orders, and I conduct show cause hearings for individuals' failure to appear in my courtroom. With that, there are a couple of statutes I want to remind everybody of. I hope everybody is familiar with the statutes, but we've got the inventory statute that requires all inventories to be filed within 60 days of appointments. In addition, we have a property management statute that requires a property management plan be filed 60 days from appointment. Mr. Burns and I, here at a later date, further in, will go over the requirements of all of these. However, I want to remind everybody on property management plans, you are required to file them. They are not the same as an inventory. Here recently, we've come into some issues where we've had inventories filed and no property management plans filed, or vice versa. Whilst the inventory and the property management plans do provide some similar information, they're not completely redundant. The inventory just gives a generalized information to the court. The property management plan is providing the court with what you intend to do with the respondent's assets and how the income is going to be paid and the expenses that are going to be incurred. We also have accounting statutes in which an interim accounting, if you've just been appointed as a conservator, has to be filed 30 days after the 6 months of the appointment. There's an annual accounting requirement in which annual accountings are due 60 days from the date of the interim accounting after, then that's annually. So essentially you file your interim accounting the 6 months after you've been appointed. And then every year after that, from that point forward, you have an annual accounting due. And then finally, we have what we call a final accounting upon when the respondent passes, in which has a 120-day requirement that the accounting be filed after the date of death of the respondent. We also have bonds that are required under statute, and I will go into detail with that here in a few minutes. Statute also prohibits the sale of property under 34-1-116. And then the statute does provide for the payment of fiduciaries and the going about or how fiduciaries shall be paid and what the court will look for in regards to that. And so when we look at all of these statutes coming through this entire presentation, me and Mr. Burns will be going over each requirement, the things that we look at, some practical tips that he's encountered as not only an attorney for conservators, but also as a private conservator over individuals. And I, as a private attorney prior to becoming probate master and addressing some of the issues that I currently see in accountings, bonds, property management plans that have come before me for review. And with that, I will turn it over to Mr. Burns to discuss some relevant forms and resources.
Yes, good afternoon. This is Tony Burns. As Ms. Johnson mentioned, I'm an attorney in the Nashville area. I have experience with guardian ad litems, attorney ad litem roles, and have been and am a conservator over the person and property, or one or the other. And what I want to do first is go over some forms and resources that I use, and I learned about a couple today. So I want to list a few, but then afterwards would like some input from the group on other resources that you guys find particularly useful. What I generally do is first, the county that I'm in, look to see what forms they have. I try to use the forms for the county that I'm in. That's what my idea is, that's what they're used to. They put it out there for a reason. So I try to use those forms. If there aren't forms or they're not quite applicable, I have a habit of going to the Davidson County site and looking at those forms. I find that those forms are helpful either to use directly or to borrow from. Also, the Office of Conservatorship Management is a good resource. Of course, the CAT website has reference materials, and an important one that we don't want to overlook, and it's easy to overlook, is the Tennessee Code Annotated. I sometimes have the idea of, I know what it says because I've read it several times. Let's just get going. But I need to reference the exact words in some instances because I've got a general idea based on other circumstances. So don't overlook reviewing the Tennessee Code and looking at that. The local rules of court, mighty important. There is the Tennessee Courts website, has a list of local rules throughout the state, and that I found that to be a good resource. And other resources that I've learned or that I did not put on here is, as Judge Hagan mentioned earlier, the Wilson County Clerk and Master. They have forms available and resources. Also, the Tennessee decisionmaking.org, which was earlier today. I have not I'd not previously been to that website, I don't believe, or not in a while, and need to review that and look through that. In the past, I've also used, I believe it was the Hamilton County website for forms and suggestions on how to do things. But if you guys would, in the chat session, add some of the more popular ones that weren't mentioned, ones that we can't do without, or maybe ones to avoid. So if you don't mind adding those in as we go through this. But the topics that I want to, what I'm going to cover generally is expenditures, then the property management plan, the sale of property, practical items as it regards to finances, and common issues to avoid. On expenditures generally, we got to realize we're dealing with somebody else's money, and we have to report what is going on with their money. And when accounting is due, the accounting needs to be straightforward. There's a clear paper trail. And in that fashion, what you want to do is make it as simple as possible. If there are expenditures that are on behalf of the respondent or ward, then those payments should be made directly from the ward's accounts. So routine expenses and expenditures from the ward's estate are to be paid directly from the ward's conservatorship checking account, so that each expenditure is easily traceable and identifiable. Payments made on behalf of the ward should not be regularly paid from a source other than the ward's funds. If reimbursement will be sought, especially if reimbursement will be sought, because reimbursement is not ideal. So if we want to ideally pay things directly from the respondent's funds, and by that the preferred method is generally checks. They are straightforward, easily trackable, and identifiable. Other options are direct pay or bill pay. These are acceptable methods if the appropriate information is provided. It's got to, again, the paper trail's got to be clear. It's got to identify how much was paid, who was paid, when was it paid, the date of the payment. And all of this needs to be clear for the probate master in order for those type of payments to be acceptable. Same thing with the debit card. They're acceptable provided that the paper trail is there. The bank statement provides who was paid, how much was paid, the date and location of purchase. Again, for accounting purposes, we want this to be transparent. But credit cards are not desired. They're not allowed absent the court's explicit approval. And if approved, I imagine Ms. Johnson is going to get into this a little bit later, but if by chance a credit card is approved, the statements must be included in with the accounting. Again, we've got the idea of it's got to be transparent. Anybody should be able to walk across, see what's going on, and understand it by tracing the accounting and the documents. What is a no-no, and I can't think of many good circumstances where it would be a good idea, is a cash or a cash equivalent. They're just not permitted. There's a lack of paper trail. You take cash out of the ATM or write a check to cash, who knows what actually happened to it. And particularly if you've got suspicious or paranoid people involved, whether it's the respondent or the respondent's family, don't invite extra questions and extra scrutiny that's not necessary. It's kind of like going through the videotape in the house and going to the house and the contents. Just avoid those troublesome areas. Now, as was said, the direct payments are preferred and reimbursements. Oh, wait, I skipped around. Approved payments. Ideally, any payment that is made out of the respondent's funds are court approved prior to being incurred. The conservator should not be financially obligating the award without prior court approval. However, under certain circumstances, expenses may be incurred against the award's estate without obtaining prior approval from the court. However, if the court determines that that expenditure is inappropriate, such expenditures may become the personal liability of the conservator. Ms. Johnson's going to get into more details on that, but keep in mind, you only pay for things, ideally, you only pay for things that have been approved, except for emergency situations and other factors that Ms. Johnson will get into in a little bit. Now back to the, skipping around. Obtaining approval for expenditures are generally obtained or achieved in two different fashions. One by motion and secondarily by the property management plan. Depending on the circumstances, one or both of these methods may be appropriate for obtaining court approval. By motion, the conservator files a motion with the probate clerk that requests the court approve the expenditures. The hearing on the motion would be heard prior to the expenses being incurred. The motion should state why the expense is necessary and provide the documentation regarding the expense, a quote, and rationale for the purchase. The approval for motion can be achieved in a 2-week period. For example, if you want to change the type of investments, repair roof, updates to real property, those may be more appropriate for a motion. To approve according or by a property management plan, the conservator may identify the types of expenditures that are expected from the ward's estate inside the property management plan. And upon approval of the property management plan, those identified expenditures are approved as identified in the property management plan. If there's changes written in or made to it, it's as it is approved by the court. The procedure for approving the property management plan takes at least 30 days. So in many instances, this just simply may not be an ideal method to make the changes. Now, what I keep trying to go back to is the reimbursement generally. As mentioned, direct payments from the respondent's estate are preferred, but sometimes it's not practical or it's not possible. Occasionally, it's acceptable if the purchases are going to be under $1,000. For example, if you're at the grocery and you have left the checking account for the conservatorship at the house. Go ahead, you could, in many instances, I believe it would be appropriate to go ahead and finish the shopping and pay for the groceries for the ward as you typically would and pay out of those expenses. But it's not a habit. If it's going to be a habit, you need to get it in the property management plan and get it approved and changed. Oversights, mistakes, document it. And if it's an amount less than $1,000, documented in the accounting and so forth. If it's an amount that's going to be higher, like your $1,000 or more, don't reimburse yourself without getting specific court approval. You need to be able to point to anything, especially when you're dealing with somebody else's money. You need to be able to point to the authority and explain why you are paying yourself out of the funds of the respondent. Yeah, and again, we want to avoid and minimize the payments for expenditures not previously approved. We're dealing with other people's money and we have to answer to the court, and we have a fiduciary duty to keep these things straight. And I am running way ahead. The next topic that I want to discuss in a little more detail is the property management plan, and that is TCA 341115. So when the conservatorship is established, the law requires that the conservator outline a proposed property management plan for the ward's property in the petition for conservatorship. However, it's generally recognized and understood that that may not be possible, and that I think it's often 60 days are given from the date the conservator is appointed to file the property management plan. However, the court may waive it and the court may order otherwise. That's kind of the typical way that it seems to happen. And again, if the clerk for the county you're in has a form for the property management plan, consider using that form. The property management plan is a budget of sorts. It's to assist the conservator, the court, and interested parties, including the ward, in understanding and monitoring the financial activity and condition of the ward's estate. It is to identify all of the ward's anticipated income and expenses, and it should identify the ward's investments, if any. The actual spending from the ward's estate ideally matches the amounts identified in the approved property management plan. However, from a practical side of things, that may be impossible. So when there are discrepancies or variances in the property management plan and what happened in reality, you want to document those with the accounting. Why is there this deviation? Provide documentation if it makes sense. Just idea is to make it clear what is happening, what happened, and why. The identify expenses in the property management plan, as we talked about before. If the expenses are in the plan, when the court approves it, those expenses are approved, and the conservator may pay those without the motion or further intervention from the court. The more time-sensitive and unusual expenses are probably more appropriate for the motion. That'll give the court opportunity to ask more detailed questions to get a better understanding of what the funds are proposed to achieve. What are we actually after? And the court may have a better idea on how to achieve that outcome. The court needs to be able to review and see what exactly is going on in some of the more unusual circumstances. And I think often we kind of have a feel for what is more straightforward and what may raise questions. in the property management plan, all of the wards' anticipated income should be identified. And if the Social Security Administration representative payee is different, that should be identified in the property management plan so that it explains why money is not coming into the conservatorship and is not being accounted by the conservator. The court's going to have questions on that. So go ahead and include that information so it doesn't waste everybody else's time. And a good deal of these things we've talked about, from the direct payments and the providing explanations, providing a document, is to save everybody time and money. If the court doesn't have to call and ask, what does this mean? Well, I need a receipt for that. You're not having to field questions as conservator or the attorney, and the court's not wasting their time. Everybody's got a lot more important things to do than hunting down little things like that. It's a waste of time and money, and we shouldn't waste that those expenses. When the property management plan, once it's approved, and if circumstances warrant it, you can amend the property management plan at any time. It's a process. So as things change, you would update a amended property management plan, send that out to all the interested parties, file with the court. Then there's a 30-day waiting period for everybody to make comments or complain, object, and whatnot to the amended property management plan. At the end of the 30-day period, the court may make a determination based on the filings. If it's straightforward and makes sense, the court very well may approve it. If, however, somebody made an objection, or if it's not quite clear to the court, you didn't provide certain information, they may decline it or schedule a hearing to discuss the matter, to discuss the property management plan and the appropriateness of it. And if that's the case, we've added even an additional time. So again, keep in mind that you want to provide all the relevant facts, not too much. Don't overwhelm the court. They've got lots of things to review. I think that's about it for the property management plan. The next topic I have, and I'm still running a little fast, is the sale of property. So no, the conservator needs to get approval from the court when they intend to sell property or assets of the ward, unless the fair market value is under $1,000 or the property is a vehicle. Now, what gets some people is it's a vehicle, whether it's a Yugo or a Porsche or a Ford Escort, an old Ford Escort, or a BMW. A vehicle is a vehicle. And that feels a little unusual that they are all treated the same. But if it is, if the item of property has a fair market value of under $1,000 or it is a vehicle, then you do not need specific court approval before making the transaction. However, you still have to document, prove that this is what you sold the vehicle for. Provide the documentation regarding the sale of the vehicle or the item, the bill of sale, document it. That still has to be provided in the accounting. If the sale is going to be for an item that has a fair market value of $1,000 or more, except for vehicles, then a motion to the court would be required to sell the property. Next, the sale of real property. If there's a need to sell real property in which the ward or respondent has an interest, an ownership interest, that should by local rule be initiated by petition. And again, you want to include that the court will want to know the details of the sale. Once a contract is submitted, the court will have to specifically approve the idea of selling the property and the specific contract. So there is time involved in a fair amount of time in selling real property.